Thank you very much. Morning again to everyone, distinguished colleagues, morning. I am very honored to be able to chair the first session of the 6th Annual Symposium on Law, Governance and Society. This session is dealing with protecting other people's money, financial regulation. And you would have seen from the program the different themes that the presenters will touch on. I won't go into too much detail. All I will say is you will get an overview of what occurs now and then 2020 and beyond. I'm going to give you a twist of a Star Trek theme. We will go where we all dare to go. I will just give you an overview of how we expect this production to run. Dr. Ali keeps calling it a production, so we want the production to run seamlessly. We will have 4 speakers. I will be introducing each speaker. They will make their presentation. We will ask you to send any comments or queries you have in the chat. You can put it in the chat or Q&A, so you can type it in. At the end of all 4 speakers presenting, we will then take as many of the questions, comments that we can accommodate in the period of time, while ensuring that our production runs very smoothly. So, and then at the very end, I'm going to ask you to complete your evaluation forms before the end of the conference. I will remind you again, we are a group that live on reminders. So I will remind you again at the end of the period. So without further ado, I'm going to introduce our first presenter, Dr. MacDonald, CBE. She is a former board member of the United Kingdom Financial Services Authority, an expert in international financial regulation and senior advisor to Crito Capital. Dr. MacDonald is the author of a number of books and many articles, including Holding Bankers to Account, A Decade of Market Manipulation, Regulatory Failures, and Regulatory Reforms. And this was published by the Manchester University Press in 2019. Dr. MacDonald, over to you.
Thank you very much, and thank you very much for your welcome. And I have enjoyed what I have heard so far. That's been terrific. What I want to do is to look at different approaches to financial regulation as they have changed over the years. And I'm going to start near the beginning of the establishment of financial regulation in the UK, because it was not actually as early as you might think. And I'm going to refer to Sir David Walker, who was chairman of the Securities and Investments Board. That was the precursor of the Financial Services Authority. Just before he took over as chairman, an extremely complicated and long and detailed rulebook had been introduced. And Sir David decided, no, that's the wrong approach, that regulation should focus on principles. So he devised 11 principles, which actually still are the basis for further regulation in the UK. So you can find the 11 principles on the Financial Conduct Authority, as it's now called. You can find them on their website, and that is quite a separate. You don't have to wander around the website, you can just find them straight away. And I'm just going to give you 1 or 2 examples of the 11 principles. I guess I always worry a little bit that the number's 11 and not 10, because then I think of the 10 Commandments, and the number 10 therefore seems to me to be more appropriate. But anyway, we've ended up with 11 principles. And you will see, as I quote 1 or 2 of them, that those principles are really rather broadly based. For example, integrity. A firm must conduct its business with integrity. A firm must conduct its business with due skill, care, and intelligence. A firm must pay due regard to the interest of its customers and treat them fairly. Just those examples I have given to you sound pretty obvious. I mean, what else would you expect a firm to have to rely on as its guidance? But life hasn't always been as simple as that. Before the great financial crisis, as it is now called, the principles-based approach to regulation seemed to dominate, and that was linked with light touch regulation and risk-based supervision. At that point, we had joined the European Union, and as you may know, the EU is fond of extremely detailed regulations. It's a different approach to law. Most of the European countries, on the Western European countries, had been subject to the Napoleonic Code, and the Napoleonic Code is still the basis of their law. So they tend to go towards a much more bureaucratic, detailed approach. And the UK was trying to move away from that. Risk-based supervision prior to the financial crisis became very much a popular approach. What it meant was that the regulators should try and assess which of the institutions it regulated were likely to be at the most risk, and what types of financial product or what kind of market processes were likely to cause the most risk. One of the regulators I heard saying, senior managers know how to run their business, and we, the regulators, do not. But then you see, the problem is that the riskiness of a financial institution can vary depending on what changes have been made. Sometimes it could be a change of a chief executive, or it could be a merger or an acquisition, meaning that the same chief executive and other senior staff were now managing another line of business with which they were not particularly familiar, and one which could change the risk profile very quickly. So that created a problem targeting supervisory resources where they can be used to best effect, as Basel put it at the time. The problem with that is that the risk profile can change too quickly, and if you're focused on one aspect of risk, you may miss out and avoid the others. And certainly the light touch regulation in the UK did not work when famously the Royal Bank of Scotland, for example, was not well supervised, and the then chief executive, popularly known as Fred the Shred because of what he did to documents before he was finally pushed out of his position, little attention was paid to the riskiness of the mergers and acquisitions and the management of the bank there. It's too small a team, too few people supervising it, and too much taken for granted that a name like the Royal Bank of Scotland was the name of a bank that surely was not going to fail. The financial crisis changed all of that. And after the financial crisis, as I expect you know, where you are as well, they were all called into question. Instead, policymakers, politicians, and regulatory authorities issued thousands of pages of new rules and regulations. That was the case particularly in the USA with the Dodd-Frank Act, with the introduction of the so-called Volcker Rule, disallowing banks from being able to engage in speculative activities on their own account. The Volcker Rule, by the way, itself took up about 1,000 pages of regulation. So how you were meant to understand it and apply it was obviously going to be extremely difficult. And now again, faced with such very detailed rules and faced with COVID, we may see something of a shift again, with the fact that banks have had to lend, to distribute monies to small businesses, to individuals during the COVID crisis in an attempt to support people during the crisis when, through no fault of their own, of course, businesses were closed down and individuals were confined to their homes. So what kind of direction should we go in now? I think we need to go back to the principles, and that those should be very clearly in our minds. And if I mention just one of them, a firm must pay due regard to the interests of its customers and treat them fairly, because as you may know, in a number of countries, regulators have had to warn what? That fraud is on the increase, that people's bank accounts are being hacked into and emptied of their funds, that people in desperate needs of money are being offered all sorts of ways of obtaining money quickly, but these turn out to be scams. So the banks themselves should be taking care of their customers, warning them about the possibility of fraud. One of the bank branches that I pass has an interesting notice on its door, which actually has quite a good point. It says, fraudsters can't spell. And you might have noticed that yourself, that when you're invited when you receive a letter or some sort of communication by email, it's often misspelt, or it's not quite good enough in terms of grammar of whatever language you speak. So warning their customers, protecting their customers, and then reimbursing their customers if the banks have failed to observe what is going on is very important, but not always done. So what is my approach then with principles-based regulation? No, as I've illustrated for you, those principles are very broadly based. So how would you actually apply them? What does it mean in terms of the details of the activities which people employed in financial institutions have to carry out? My approach is very much this: have the principles, but then two further things must happen. The particular regulations must be clearly derived from the principles, and you must be able as regulators to show, yes, if you follow these regulations, you will be well on the way towards achieving the kind of outcomes that we want to see. And frankly, if you are running a business, you should want to see as well. Because if you really do run the business efficiently, honestly, and in the interests of your customers, then that is good business. And it means that you stay in business, but it also means that you fulfill the regulations and you meet up with the principles. That should be the aim from the regulatory point of view. What about all the employees working for a large bank? You may well have begun to develop this where you are, and we are beginning to develop this in the UK and elsewhere. Some banks are introducing ethics and regulatory training for each individual on an annual basis. so that each individual knows what changes there are, what standards they are expected to meet, and how they should apply them. They have to pass this test annually, but it's not a multiple choice question. Instead, they are presented with scenarios, and they are asked to say, a customer comes in and asks you to do this for him or her, or you think you can cut corners this way. So you set out several scenarios, there has to be more than one, and you give the employee, the trainee, several options, and then it's up to them to both point out which option they would adopt, and better, if you can do it, maybe by group discussion afterwards, why you selected that particular option. It shouldn't be obvious, you know, sometimes with the multiple choice questions, it's pretty obvious which one you should select, or you can just guess. This, I think, takes teaching and learning much further than that. And then following that, and I think it's all part of the same, these are the principles, these are the regulations which ensure that the principles are applied to all that a particular financial institution, whether it's a bank or an insurance company, does. And then we have also introduced, or developed, I should say, because actually it was introduced a long time ago. It was introduced in the 1990s, but I would say not developed or applied properly since then. Senior management responsibility. Now, as you know, banks, insurance companies are often large, complex, and sometimes global institutions. Even if they're on a smaller scale than that, it's not very easy to know what any individual is getting up to at any particular point in time. So for senior managers to take responsibility for the actions of all of their employees also means that you have to structure your organization in such a way that not only do you engage in the kind of training that I have outlined, not only do you have compliance officers to check, but what you also do is you have proper lines of reporting, proper management information, and red flags. I'm a great believer in red flags. That when an employee is engaging in some particular activity which is dubious, then what you must have in place is something that, could be something wrong here. It may not be, but it does mean that the red flag means that you go and investigate, find out what is going on. As has been mentioned to you, I wrote the book, Holding Bankers to Account. And what I examined in the book was the manipulation of Forex benchmarks, the manipulation of LIBOR, and the manipulation of gold and silver prices. The very useful thing, which happens in the UK, but not so much in the US, is that, and I was able to draw on this because what it showed you was particularly Tom Hayes, who was actually one of the main persons involved. He's now in prison in the UK, was one of the main persons involved in bringing about this kind of manipulation, title to one book describing his activities in much more detail than mine, called it The Spider's Web. And he was in the center of the spider's web. And he had colleagues, co-conspirators, I should call them, in other banks. And they would agree to put in what you're supposed to do each day, their estimates of what the interest rate would be for loans, long-term lending. I'll put it very briefly there. And because that affected the derivatives trading, they wanted the interest rate to be at a particular level. So they would all get together and put in very much the same interest rate. Bear in mind that this could be a couple of decimal points. So they put in the same interest rate in order to benefit one person who had a lot of derivative trades which were closing on a particular day. It really is worth reading exactly what people got up to, how it was carried out, and how it went on for so long, a number of years, that this kind of cheating on setting the LIBOR rate, which then determined the rate for lending, long-term lending, that LIBOR rate was one that was used throughout the world. So your own banks may well have been referencing the LIBOR rate at that time. The advantage in the UK is, and this is where we could use the principles, not a specific rule, we were able to charge each individual by setting out in great detail the final notice, as it was called, issued by the FSA and then the FCA, run into 30 or 40 pages. And you would see there, and I drew on that material in my book, very lengthy exchanges between one, Tom Hayes, and his co-conspirators in other banks, all engaged in derivative trading. And then how they cheered each other on, and how Tom Hayes would reward his co-conspirators with a bottle of champagne delivered to their office. Of course, the rewards were in fact much greater than that, because the shift of a decimal point or two meant that a lot more money was earned on closing that particular contract on that particular day, and therefore their bonuses went up. The great advantage to that was, since the rules weren't that specific, was that you could see exactly what was being done, and each of the charges that were made against those individuals were made on the basis of one principle or another. And so, as I sometimes say to lawyers or to other regulators, well, if you can't get them on the rules, you can surely get them on the principles. And that is the great advantage of having clear-cut principles, guiding behavior, guiding the regulations, guiding the training, and above all, guiding the senior managers concerning the manner in which they were meant to conduct their business. I'm going to pause there. I wasn't interrupted, so I think that I'm just about on time, I hope, in the presentation that I gave. And thank you very much for your attention and the opportunity to be here. I did look a bit enviously, I have to say, on the pictures of where you usually had the seminar, and wished I could be there right now, but it's lovely to meet you all in this way, virtually as well. Thank you.
Thank you so much, Dr. McDonald. You definitely stayed within your time, so I did not have to do my 5-minute reminder and all of that. A little earlier, I had my curtains open, hoping to show you bright, brilliant Jamaica. It really isn't. We are clearly expecting some rains today. It's getting very dark, so welcome to the Caribbean. I will now move on to Miss Ingrid Pusey. BA honors, LLB honors, LLM, so we won't hold the BA against you, Ingrid. Ingrid is the General Counsel at the Financial Services Commission, Jamaica, FSC. She has been employed to the FSC since 2003, where she has gained significant experience at a senior level in the area of securities regulation. During that period, she was involved in the shaping of the legal and regulatory framework for the securities industry in Jamaica and was part of the core team that achieved the 2013 amendments to Jamaica's Securities Act that facilitated the invitation for the FSC to become a signatory to the multilateral Memorandum of Understanding of the International Organization of Securities Commissions, which was a huge task and great achievement for the FSC and indeed for Jamaica. Ingrid, I hand over to you.
Thank you very much, Madam Solicitor General, for your kind introduction. My apologies for the delay. Distinguished members of the judiciary, colleagues, good morning. I am here to discuss the topic, the challenges of new financial products. If you will just bear with me for a minute, I'm trying to share my screen with you. Hope you can see the screen clearly. Thank you. As you can well imagine, there are many challenges that regulators may face when dealing with innovation and new products. For the purposes of this presentation, I will bear the perspective of a securities regulator and focus on the following areas: keeping a pace of the industry, deciphering a product, the question of jurisdiction, and determining the appropriate regulatory framework for a product. I chose the securities industry as the model because I find that this industry uses technology and innovation to rapidly develop new products. It is said that financial products may be as varied as human ingenuity in their nature, form, and appearance. New products may or may not incorporate new technologies. For example, there may be a product that has both securities and insurance components, or a product which, though offered in other countries, may be offered for the first time in Jamaica. In my view, however, I find that technology is a common feature of most new products that we are seeing being developed and marketed to the public at large. The term financial technologies, or fintech, is defined as innovative business models and emerging technologies that have the potential to transform the financial services industry. This slide shows an actual advertisement from a very well-known Law Street financial firm. You will see that in inviting applicants for posts at their firm, they have asked or required a PhD in a quantitative field such as mathematics, engineering, physics, or computer science. This demonstrates that persons who develop new financial products want persons with the talent, training, and experience who can develop cutting-edge products. This slide shows the current financial environment and has features such as robo-advisors, robotic advisors, that is, micro products, mobile services, online trading, data analytics, and so forth. Micro products, for example, are available in many countries, emerging markets such as Kenya and India, where insurance products can be accessed from remote areas using cell phones. This results in faster and cheaper products and services being offered within the industry. The reduction of barriers to business, barriers for individuals to access finance, and it promotes industry growth and development. The mandate of the Financial Services Commission is to protect customers of financial services. We must supervise and regulate financial institutions, control and manage risk, and promote public education. The regulator must therefore be able to keep up pace with the industry. They must be able to understand the industry in order to be able to conduct public education sessions, and in fact to monitor, supervise, and assess the conduct of the players. The question therefore is, what should regulators do? Well, some of the strategies that I'm proposing is constant training, knowledge, and retaining that knowledge through staff retention, dialogue and consultation with industry, leaning on the experience and expertise of your counterparts, both local and overseas, cooperation with other regulators, and well, we can't avoid perhaps amending or changing the laws. The next challenge that regulators face would be the deciphering of a new product. So imagine yourself as the young gentleman at the top right-hand corner of the screen, and you have a file with a product that is being offered for the first time in your jurisdiction. And let us take Jamaica, the FSC, someone in our securities division. I am going to use as an example an actual product that was offered, and I'm using the case of the US SEC versus Company Interactive Incorporated, Southern District of New York on September 30th, 2020. The product in question was an offering for sale of digital tokens. The company promoted an opportunity to integrate chat with true digital commerce within an existing user base. So picture yourself as the analyst at the desk. What would you do? Is this a securities product? So giving you a little background about this company. The company was in the business of providing mobile messenger services, which over time became unprofitable. So they tried to sell the company. However, their efforts were futile in doing so. And so they created an alternative business model, and given the popularity of digital currency, they decided that that would be more profitable. So they decided to create and sell digital currencies. The tokens would be used to buy and sell digital products across different applications. The company conducted roadshows and other promotional events, marketing the tokens to potential buyers. And the Ontario Securities Commission and the US SEC, on becoming aware of the marketing of the product, advised the company that they would be issuing securities. The US SEC made a complaint to the district court because the company went ahead and sold a portion of the securities without registering them. Another portion, they attempted to register under an exemption. The district court agreed with the US SEC that the product was in fact a security. They felt that the company engaged and sold investment contracts contrary to the Securities Act without filing a registration statement and without an exemption from having to do so. Their findings were based on an examination and analysis of the complete arrangement, not just the outward appearance of the product. So we will look at the arrangement. The company pre-sold tokens to select persons, we call them accredited investors, such as wealthy persons, investment funds, and so forth. And those pre-sales were done at a discount. So the money was given to the company by the accredited investors prior to even the creation of the tokens. And the bargain was that they would get the tokens at a later date and at the value, of course, that the token would be at that date. So you see there is a profit element from the start. Earnings from the pre-sales would then be used to finance the creation of wallets, which would allow the holders to view their balances and so forth, and receive premium digital stickers, which the use of which are yet undefined. Only a finite amount of tokens would ever be created in order to guarantee scarcity. It was the company's intention that the tokens would be used for buying and selling across numerous applications. A number of enterprises offered opportunities for the tokens to be used across their applications, and the company promised those persons special rewards. So we see that the proceeds of the sale of the tokens were to be used to finance projects aimed at promoting the use of the token and increasing the demand for the token. In summary, the sales were there to promote the development of the product ecosystem. And that ecosystem meant the environment in which the product would trade, the applications, because that they would be traded across, because they found that some of the existing applications were a bit slow and inefficient for their purposes. They would also enhance their original messenger services so that could be used to promote and facilitate the purchase of the token. The company would retain a significant portion of the tokens for themselves in order to profit from any appreciation in value. And when they promoted the sale of the tokens, they promised persons that they would make a ton of money. So the court said the undisputed facts show that, yes, securities were being offered and sold. They used the Howey test, that is the test in the case of the Securities and Exchange Commission versus Howey, and that has been a case that has been used in Jamaica in several cases in recent years to determine that certain products offered in Jamaica have been investment contracts. And the court used that case because in the Securities Act that they looked at, the definition of securities included investment contracts defined as a transaction or scheme whereby a person invests his or her own money in a common enterprise and is led to expect profits solely from the efforts of the promoter or third party. So applying the elements of the definition to the facts in question, we see where the purchases of the token by those to whom the tokens were pre-sold, the accredited investors, and later to the general public constituted an investment. And as I said before, the tokens that were pre-sold were done at a discount. So once they got the tokens in hand, the actual value of the token would give them a profit. There was a common enterprise. There was a common enterprise because the company pooled sales from the token to create the infrastructure for the token and boost the value of the token. So they pooled and invested the proceeds to increase the range of goods and services from which all the investors would financially benefit. And finally, there must be demonstrated the existence of a reasonable expectation of profits to be derived from the entrepreneurial or managerial efforts of others. So the court could look at the promotional materials, public statements, promises, and so forth of the company, where the public was promised that they would make a ton of money. Persons were told that if you bought early, you would make money, because you'd be purchasing the tokens at a discount. Also, they promised to only distribute a finite number and then increase the demand for the product. So once the demand increased, the value of the tokens would inherently increase. So as regards the managerial efforts of others, it is useful to note that without the efforts of the promoters, the investments would be virtually worthless. It was undisputed that the company had to be the primary driver of the ecosystem. the stronger the ecosystem that the company built, and that would be the environment for the sale of the token, the greater the demand for the token would be, and that would result in an increase in the value. And so the SEC, they found that the company had issued an initial coin offering, which was a fundraising event, which went done with securities with a profit-making objective would be a security. And so taking you back to Jamaica, being the person at the desk, if we look at the Securities Act, you see that the term investment contract is also a part of the definition of securities. And we also have a provision in the Securities Act which prevents persons from issuing securities without being registered with the commission. As such, the FSC could take the lead from the approach from the US regulators in addressing the problem, because our courts have applied the Howey test in determining the definition of the term investment contract. So what are the lessons here? Yes, the regulator will be faced with new products. At face value, this was a messenger system that was with the offering of tokens. But when you drill down, when you peel away the skin, you could find that an actual securities product exists. So you have to look at the entire arrangement. So the challenge is for the regulator to be able to decipher the product, to drill down. But we're fortunate to have statutes wide enough to allow us to address those problems. The next issue is one of jurisdiction. Because as we said, you have cryptocurrency in an investment contract, which is a securities, you have a mobile messenger. So would the regulator be the OUR, the Bank of Jamaica, an overseas regulator, the Financial Business Commission, the FIB? The persons were breaking the law. So it could have been a financial crime. We see that the Bank of Jamaica Act speaks about the currency of the island. It states what it should be and says that no person other than the bank shall issue in Jamaica notes or coins, etc. And so the Bank of Jamaica may have an interest in the product had that situation occurred in Jamaica. And so what would be the approach? Would the regulators be tripping over themselves in order to regulate the product or the service providers? And there are certain approaches that we can take to determine how to address the problem. You can look, for instance, at appointing a lead regulator, depending on the model. So for instance, if the model is a bank-led model or a financial institution-led model, where the mobile channel is only seen as an access channel for the services, then one may want to defer to the financial regulator as the lead regulator. Regardless, in order to address the issue, once a regulator has a statutory remit and at peril of being defunct, not carrying out his duties, then we really need to have channels for collaboration, cooperation, information sharing, and coordination amongst regulators, maybe by way of MOUs, memoranda of understanding, or otherwise. And so the legislation should allow these regulators to share information amongst themselves and to cooperate. And so we have to be forward-looking in terms of the list of persons to whom a regulator can disclose information to, because it might be that the Financial Services Commission will have to disclose information to the OUR, for example, even though they're not listed amongst the persons in the FSC Act to whom disclosures can be made at this time. And the final challenge that I will look at, in the interest of time, is determining the appropriate regime. So we have already decided that the product falls within our remit. The regulators decided that the Financial Services Commission, or the securities regulator, is the lead regulator. Is the regime that we have in place, are the rules that we have in place tailored or appropriate for the product in question? Now, the Howey test was quite helpful to bring the product under the regulatory net. It is said it's a flexible, not static product, capable of adaptation to meet countless and variable situations. And so substances should prevail over form. And we see where that has brought orange groves ostrich farms, partnerships under the remit. Now, in terms of how we approach regulation, we need perhaps similarly broadly worded powers in order to address the safety, the conduct, the soundness, and the regulation, the overall supervision and management of the enterprise and the product. And so we look at Section 49 of our Securities Act, the Jamaican Securities Act, for instance, which has a broad, what I would call anti-fraud provision, which allows the FSE to take action where someone employs any manipulative or deceptive device or contrivance or scheme. And those words are so broadly interpreted that countless ranges of actions could be used and brought under the net for us to take action against misconduct in the industry. Now, recently, in June 2020, the SEC published a press release warning persons against certain frauds, which I would call COVID fraud, because the matter involved person dumping stocks under false promotional assertions that the company would produce medical quality face masks in order to capitalize on the pandemic. So as not only technology changes, but the environment changes, persons will seek to capitalize on changes in the environment, in politics, in health, in order to develop products, because at the end of the day, persons want to take advantage of any opportunity to make money. And so the SEC used a provision, Section 10B of the Securities and Exchanges Act, which is equivalent to our Section 49, to file a complaint. In their complaint, they filed a complaint to the courts, alleging that these persons had defrauded the public. So we see where very widely worded provisions are quite useful in helping the regulator to deal with new and evolving challenges. And then when you look at the services provided, because the focus in our Securities Act is the regulation of the service providers as opposed to the product itself. Except in one or two cases where issuers, they have a light regime and there's a detailed regime for collective investment schemes, we tend to regulate the dealers and investment advisors. And in Jamaica's law, you see that investment advice business is defined in a very broad manner. Just the business of advising as to the buying and selling of securities. And so in Australia, the question was whether or not this definition could extend to the sellers and marketers of computer software, which generated recommenders for users to buy or sell securities. And they applied their definition of investment advisor so broadly that it incorporated those persons, because otherwise we can, it would be useless to go after the robot or the computer in that case.
No, we're just reminding you have to start wrapping up.
Okay, thank you very much. And so I just make one point and then turn over to my colleague, Mr. Morgan, who is going to develop on this area. In order to tailor the regulation to suit a product, I just wanted to point out that you have companies which are startup companies, which tend to be structured as private companies who want to raise funds and take advantage of crowdfunding opportunities, maybe online, where you can have millions of investors. However, the Companies Act prevent private companies from issuing invitations to the public to subscribe for shares. And so the question is, how does that limit the ability of persons in startups to gain their monies that they need in order to develop their business? And so if you have provisions like that, basically you're trying to fit a square peg into a round hole. So you have to ensure that the regime is very relevant for the product or services that you're regulating. I will now hand over to you, Madam Chair.
Thank you so much, so much, Ms. Pusey. A lot to think about. And I hope none of that involves new legislation anytime soon. And now I'm going to introduce Mark Anthony Morgan. Mr. Morgan presently works as a senior legal officer at the Financial Services Commission, and I do believe Ms. Pusey is his supervisor. In that role, he has had a bird's eye view of various issues faced by a financial regulator tasked with investor protection. And he has also had the opportunity to participate in various regulatory reform initiatives. Over to you, Mark.
Yes, thank you. Thank you, Madam Solicitor General. Thank you for that introduction. And thank you, Ingrid, for setting the atmosphere for my presentation. And a pleasant good morning to my distinguished colleagues present today here in Jamaica, whether physically or virtually. Welcome. So my presentation is a continuation of the discussion of the challenges of new financial products. And I shall be focusing on specifically the sandbox approach and whether it can provide a solution to the rapid innovation taking place with respect to financial products and services. So a little bit of a background about the sandbox approach. In 2015, the UK's Financial Conduct Authority, which I'll be referring to as the FCA, coined the term regulatory sandbox. A regulatory sandbox is a framework set up for by a financial regulator to allow for testing of various innovations by private enterprises on a small scale in an environment which is controlled. And regulatory sandboxes have been used as a means of promoting innovation, improving competition, and enhancing financial inclusion. All very good goals when you want to have a robust financial system that includes the entire population. However, there are a number of things to take into consideration when you're thinking about whether to adopt a sandbox approach in your jurisdiction. One, what are the regulatory barriers that would be addressed by the sandbox approach? Well, financial regulation affects the development of financial products, of course, and services. And the existing legal environment molds the financial products and services that can be offered. And as a result, the structure of the law can create regulatory barriers. For example, financial regulation is wide-reaching with many prudential and market conduct regulatory requirements, and often the penalties for failing to comply with financial regulation can be very weighty. For example, a person convicted of operating a prohibited scheme under the Securities Act in Jamaica, you can refer to Section 17B, is liable for up to 10 years in prison and or a fine. When thinking about regulatory barriers, financial service products also require trust from investors. And so non-compliant financial service providers will, of course, eventually face credibility and trust issues if their activities are not compliant with regulatory requirements, at least in theory. So in theory, compliance with regulations inspire confidence and trust to attract customers and obtain funding. Financial regulation can also affect competition because it can be more of a barrier to entry for startups, often associated with innovation, than for already established and regulatory financial institutions. Also, financial regulation, if too onerous and inflexible, can impact innovation irrespective of whether an entity is a startup or already established. Innovation, for example, may be limited by prohibitions on some activities by regulated entities, or resources may be consumed, paying costs associated with compliance with the regulations. So with that discussed, one also has to note that there are regulatory concerns about a sandbox approach. For example, from the regulator's perspective, investors may view the sandbox as a form of endorsement of financial services or products by the regulators. However, a sandbox does not change the circumstances that the financial service providers are experimenting with real customers who may suffer losses or be the victims of misconduct. Also, there are concerns about the absence of standardization, since sandbox applicants may be subject to different conditions for participation, a risk that may increase where there is a lack of transparency with respect to the assessment process. Also, the use of regulatory sandboxes may create an imbalance by giving advantages to new startup financial services and products over existing financial firms, which can raise concerns about the fairness of the process. So also, of course, when giving consideration as to whether or not to adopt a sandbox approach, one would clearly look to the benefits. So what would be some of the benefits for the regulator having looked at some of the concerns? Well, by first testing within a regulatory sandbox, regulators can get information that will hopefully help make better judgments about the viability of innovative products and services. And the hope would be it would therefore provide benefits to end users, the innovators, and also the investors that regulatory knowledge acquired. The approach would also promote a collaborative relationship in theory between regulators and regulated entities, which some would theorize would aid in the creation of a culture of compliance, which in turn can require less oversight by the regulators in the long run. A sandbox approach can also allow for a faster regulatory response in circumstances when technology evolves too quickly for the pace of traditional legislative processes. And as noted by Madam Solicitor General, it is not desired to always have to amend legislation. However, there are barriers in the legislation, or there can be barriers in the legislation to effecting a sandbox approach that the regulator has to be cognizant of. In some instances, amendment of the law may be required to permit the application of a sandbox. This, of course, particularly exists where financial regulatory regimes are more rule-based as opposed to principles-based. And we had the benefit earlier on of some discussion of the principles-based approach. So rules-based regulation, in a nutshell, revolves around details and prescriptive laws and regulations that must be complied with in order to conduct certain financial activities and to offer certain products. The theory of a rule-based system is that objective standards of behavior can be applied broadly to protect investors and to achieve a safe and sound financial system. And no need for me to spend much time on the principles-based regulation approach, but it's a shift from the reliance on detailed or prescriptive rules, and it basically relies more on high-level, broadly stated rules or principles which set standards by which financial entities must conduct business. So in adopting the sandbox approach, one can benefit from precedent set by the initial, the first we can say, leader, the FCA's sandbox program for financial technology firms. And the blueprint, as outlined here, involves objectives. And the key of the objectives is basically that the regulator's mandate kind of shapes the approach to how the sandbox is set up. And of course, the aim usually is to promote competition and efficiencies through innovation. And then, of course, we go to eligibility. And eligibility depends on the legal authority of the regulator, because only the institutions that fall under the supervision of the regulator would clearly be able to benefit from the sandbox. And where the regulator does not have exclusive jurisdiction, then of course, either the sandbox would have to be set up in cooperation with other regulators in order to be efficient. And then of course, there is criteria. So sandbox entities, of course, have to be subject to restrictions, such as the maximum number of customers that can be served by an entity in the sandbox. And they may be required to put in place safeguards that reflect the risks and benefits of the proposed innovation. For example, perhaps to be a part of the sandbox program, an entity might be required to provide more detailed disclosures to investors that participate in the program. And testing, okay, and so with that, let us move on to timing. Timing should be time-bound, in theory, to protect against prolonged probing of innovations. And next, we look at costs to the regulator and entities. So in theory, entities benefit by getting input from the regulator, which will save them costs in the long run. And oftentimes, sandbox programs are free to the entities that participate in them. However, one should note that with respect to sandbox programs, the regulator may have to take on additional human or other resources, and so there may be a cost to the regulator. However, that may be offset by, in the long run, not having to take certain actions, regulatory actions against entities that are in breach of our legislation. And so we move on to regulatory actions following tests. So of course, the ideal outcome would be that the test is successful and there is no full authorization for that financial entity or service that participated in the sandbox to offer its product or service. However, if testing fails, then the regulator may be required to take steps to ensure that that entity discontinues the provision of that service. Also, another successful regulatory outcome may be that based on the information gathered by the regulator during the sandbox, sensible revision can be made to various laws and regulations that affect financial activities in Jamaica. Oh, one moment. For some reason, this is not, the screen is not, for some reason, the slideshow is not progressing. Okay, so apologies for that. For some reason, the slideshow was giving some problems, but let me continue. So with that said, I would like to discuss the example of the FCA's sandbox program for fintechs in the UK. So in May 2016, the FCA launched the first financial regulatory sandbox. They describe their sandbox as a safe space in which businesses can test innovative products, services, business models, and delivery mechanisms while ensuring that consumers are appropriately protected. Participants were entitled to a 6-month period after which they became regulated like other financial firms. And the regime restricted authorizations to be provided to new firms wishing to test their financial product services without the cost or delay that may be involved with an application for full authorization. They provided restricted authorizations. The regime enables the FCA to provide individual guidance to sandbox firms on the interpretation of regulatory requirements to new technology. The FCA under the regime also has the power to grant waivers or issue no enforcement action letters in some circumstances. And so with that said, it would be remiss of me to not point out that Jamaica itself also has precedent for the sandbox approach. And with that, I refer to the BOJ, Bank of Jamaica's FinTech regulatory sandbox. The BOJ established the FinTech sandbox to achieve the objective of providing a platform to encourage innovations in financial services, promote competition, and promote financial inclusion. Their sandbox was established pursuant to Section 28 of the Payment, Clearing, and Settlement Act of 2010. And according to the BOJ, their sandbox is designed on 4 characteristics. 3 of the characteristics you would have heard while I discussed the FCA's sandbox. And those 3 characteristics would be objectives, eligibility, and timing. The 4th characteristic, which I would say is captured by the characteristics listed by the FCA's sandbox, but notwithstanding, the BOJ lists their 4th characteristic as safeguards. And according to the BOJ's guidelines, the safeguards for operating within the sandbox highlight the requirement for financial and client limits, consumer protection mechanisms, and risk management arrangements. Entities under the BOJ's regime can benefit also from no objection exemptions on a case-by-case basis. Another benefit of the BOJ sandbox regime is the potential for the BOJ to gather information about the benefits and risks of emerging technologies, which enables the bank to consider regulatory changes that foster innovation in financial products and services while mitigating risks. And another benefit for the BOJ sandbox is the potential for the improvement of the speed of adoption of innovation and enabling financial inclusion while mitigating risk to financial stability. At this point, I'd also want to probably point out one of the challenges of the BOJ sandbox regime would be that it would require probably cooperation from other regulators such as the Financial Services Commission. I know that their guideline says that if necessary, they will enter into MOUs, memorandums of understandings, to address these issues. And with that, I think I come to the end of my presentation. Here, I provide a list of some resources, but given that it appears to me that I'm within time, I would also like to talk about one of the real measures of whether one should adopt the sandbox approach. And that would, of course, be the outcome of empirical studies and data gathered in perhaps in other jurisdictions. And I looked at a study done by Deloitte, and basically the study noted that most firms that participated in the sandbox programs financial firms gave a very favorable review of the program. They said that they adapted to getting it, they benefited greatly from getting feedback and information from the regulator at an early stage of their development of their product or service. And oftentimes we're able to make important changes to their product or service based on the feedback of the regulator at an early stage. And so it seems to me that as the data comes out, there is some support empirically for adopting a sandbox approach. And maybe it is something that can be pursued more widely in Jamaica. And I'd also like to point out that the BOJ's sandbox program, while I'm not privy to the data from it, entities have been participating in it. I note that there's a Lasco Biz, which is an e-commerce platform allowing merchants to accept payments electronically through a website that is presently a part of the BOJ's sandbox program. And so I look forward to see how that program, the impact on that program on financial entities and services. And with that, I conclude my presentation, and I thank you for the time given to me to express my thoughts on sandboxes.
Thank you so much, Mark. I noticed both you and Ingrid had the word challenges in your description of your presentation, but I also noted there were perhaps some possible solutions as well. We now move on, but before we move on, sorry, I'm going to just remind persons that you can indicate your questions or comments in the Q&A section, which is at the bottom of your screen. And you can just type in any comments or queries you have that you'd like the panelists to address at the end of all presentations. So now we're going to move on to Professor Dennis Driscoll. So Professor Driscoll is an international lawyer. He's a former dean of the law school at the National University of Ireland, Galway, where amongst other innovations, he pioneered the first course on corporate social responsibility taught at any law school in Europe. He has also been a visiting professor at Harvard University and at Peking University, where as the Raoul Wallenberg Institute Professor of Human Rights, he in fact had the honor of being the first professor of human rights in the history of China. For the past decade, he has been giving training courses to executive management and boards of directors on responsible business practices and on corporate governance. And he conducts these training courses across Europe, Asia, Africa, and the Middle East. It appears, Professor Driscoll, that you need to now expand your reach to the Caribbean. And with that, I will hand over to you for your presentation.
Now, thank you, Solicitor General. First of all, can you hear me?
Quite well and quite clearly.
Well, first of all, hello to everyone, and sorry for the slight hiccup. I'm looking forward to making some remarks. It turns out that my own remarks will be rather different than the previous ones, because I'm going to be talking about pressure on the banks to develop a more sensitive, responsible banking. So can I move to the second slide? Okay, I want to make just one brief remark about the chaos of the pandemic. But then I want to change to, rather I want to turn to some changes which have occurred in recent years. And then I want to talk about business promises about good behavior before the pandemic. And then finally, I want to talk about responsible banking. Then, to conclude, I want to look to the future and look to responsible banking in a post-pandemic world. So turning to the next slide, please. I don't think I need to say very much about this. People will have the slides themselves, but let me just make one brief comment, really. It's hard to summarize the chaos that the coronavirus pandemic has represented. But the World Economic Forum tried a few weeks ago, and they said this: COVID-19 threatens to become one of the most difficult tests faced by humanity in modern history. I think that's almost certainly true. They went on to say the pandemic has taken lives, stirred anxiety and political drama, overwhelmed health systems, and triggered potentially lasting geopolitical changes. I think it has been, I'm not a young man any longer, I think it's been the most extraordinary thing I've ever witnessed in my entire life. And I feel so sorry for the millions who have been suffering, I must say. Well, turning now to changes. I've said here that words fail us. The changes that the pandemic has wrought, the health changes, the human changes, the societal changes, the economic changes, and the political changes have, in the words of a recent OECD report, represented an unprecedented crisis. I think that's profoundly true. I now want to look for a few minutes at some of the dramatic changes that have occurred. The first change relates to democracy. What has been the impact of COVID-19? In a report issued last month covering 192 countries, Freedom House, you may all know it, a prominent civil society organization that researches political freedoms worldwide, stated that the coronavirus pandemic, rather since the coronavirus pandemic began, democracy and human rights had grown worse in 80 different countries. Freedom House stated that governments, I beg your pardon, the next slide, please. Freedom House stated that governments have responded by engaging in abuses of power, silencing their critics, and weakening or shuttering important institutions, often undermining the very systems of accountability needed to protect public health. And they gave as examples developments in Brazil, in the Philippines, in Belarus, in Sri Lanka, and quite a number of other countries. The next slide, please. The next issue concerns labor rights. In a report issued last month, the International Labour Organization declared that its most fundamental principles and work rights were under threat. It mentioned freedom of association and the right to collective bargaining, the elimination of forced labor, the elimination of child labor, and finally, the elimination of employment discrimination. I want to say something about each one of those. The next slide, please. Turning to freedom of association and the right to collective bargaining, the International Trade Union Confederation, that is to say the ITUC, represents 207 million workers in 163 countries. They stated in their annual report in June, threats to workers, our economies, and democracy were endemic in workplaces and countries before COVID-19. Now, we are already seeing some countries take things further And under the cover rather of measures to tackle the coronavirus pandemic, they are advancing their anti-workers' rights agenda. Again, mentioning, for instance, Brazil and the Philippines. Turning to the elimination of forced labor, the ILO has reported that the COVID-19 pandemic is magnifying some of the main drivers of forced labor, especially socioeconomic vulnerability and a lack of alternative survival mechanisms. Roughly 60% of workers worldwide are in informal employment, and COVID-19 is driving them to seek a livelihood. So this has made them vulnerable to dimensions of forced labor. The next slide, please. The elimination of child labor. The ILO also fears that there will be a rise in child labor. It goes on to say, COVID-19 could reverse a generation of progress against child labor. The weight of evidence from past crises underscore the substantially heightened risk of child labor. This is because, amongst other things, families suffering economic hardship, especially in developing countries, are more likely to have their children seek employment opportunities, however. Turning then lastly to the elimination of employment discrimination, the ILO claims that COVID-19 is amplifying the effects of pervasive discrimination in the workplace. Groups commonly facing discrimination, that is to say, women, minorities, migrant workers, lesbians, gays, and others, are amongst the first to be affected by new troubling issues. This shouldn't be surprising because these groups are concentrated in insecure jobs in an informal economy without special protection or even without representation. Turning to the next slide, the next profound issue is inequality. You will all know that the pandemic has highlighted inequality in many countries. The disproportionate suffering by ethnic minorities in many countries is striking. But there are also a number of other inequalities by virtue of income, work, educational background, housing, age, pre-existing medical conditions, and so on. To take the United States as an example, the infection rate in the US reveals, at the very least, differences in suffering, as many of you, I'm sure, know. The infection, these were figures as of last month. The infection rate for whites is 23 per 10,000, whereas the infection rates for blacks is almost 3 times higher at 62 per 10,000. And for Latinos, who are mostly frontline workers, the infection rate is more than 3 times higher at 73 per 10,000. The next slide, please. Turning to the death rate, the difference in the death rate in the States is also striking. Whites have been experiencing 61.7 deaths per 100,000. Blacks are experiencing almost twice as many, 114.3 per 100,000. And the Latinos, somewhat more than the whites, 78.5. Blacks and Hispanics are more likely to work in jobs that do not accommodate remote work. Further, Blacks and Hispanics are also more likely to live in multi-generational housing, which places older, at-risk adults in close contact with younger people who may not even know they have the virus. Turning as an example, Britain, the next slide, please. Similarly, in Britain, ethnic minority groups have been disproportionately affected by the virus. COVID-19 hospital deaths for British people of Black Caribbean background has been 3 times higher than for the white British population. There are also higher death rates for Black African, Indian, Pakistani, and other Asian peoples. One of the reasons for the higher death rates is that the minority peoples tend to be comparatively low-paid frontline workers, having to work with members of the public regardless of risk and whether they want to or not. The next slide, please. Turning to the situation of other countries and regions, a recent OECD study, there are 36 countries of the OECD, a recent OECD study reveals that the coronavirus pandemic is having a disproportionate impact on immigrants and their children, who now constitute 20% of the population in many of the 36 OECD countries because of their special vulnerabilities due to employment, housing, and other circumstances. The next slide, please. Turning to Latin America and the Caribbean, a report released a couple of weeks ago by the Economic Commission for Latin America and the Caribbean, where, as of a couple of weeks ago, countries had already experienced 9.4 million coronavirus cases and 340,000 deaths, found that the most vulnerable people were, not surprisingly, the poor and most marginalized. That is to say, informal workers of both sexes, indigenous people, persons of African descent, and migrants. The next slide, please. Turning then to the issue of responsible business promises before the pandemic, a number of promises about responsible business behavior before the pandemic are noteworthy. Especially noteworthy are the solemn promises by institutional investors in the UN Principles for Responsible Investment. The next slide, please. Some of you may already be familiar with the principles. They're a set of voluntary norms that investors promise to honor in their investment activities. Although they were launched by the UN Secretary General only in 2006, now over 2,800 investment institutions representing about $100 trillion under investment have signed up to the principles, promising that they will integrate responsible business thinking into their investment decisions. A good example of one of the implications of such a commitment is the current movement to divest from fossil fuel companies. As some of you may have read in the papers, it caused something of a sensation at the time. The Rockefeller Family Fund announced in the spring of 2016 that it was withdrawing its investment from all fossil fuel companies as quickly as possible, declaring, remarkably, there is no sane rationale for companies to continue to explore for new sources of hydrocarbons. They emphasized, we must keep most of the reserves in the ground if there is any hope for human and natural ecosystems to survive. Given that the Rockefeller money was based on oil, their declaration was, I think, utterly remarkable. As to the broader picture, the fossil fuel divestment movement has grown extraordinarily rapidly. As of April 2020, a total of 1,200 investment institutions representing $14 trillion in assets had divested from the fossil fuel industry. In 2014, only a few years ago, when the movement started, it numbered 181 investment institutions possessing only about 50 billion in, there's a typing mistake, 50 billion in assets. So this movement is really quite extraordinary. Many influential investors, I've just lost my own. Many influential investors, oh, this is new to that, I added it actually yesterday. Many influential institutional investors are pressuring banks to no longer support fossil fuel investment. Only, I think yesterday, the day before, the Interfaith Center on Corporate Responsibility, with just 300 institutional members, with 500 billion under investment, announced that intends to double down on its efforts to encourage companies to address the critical issue of climate change, including in the company's own lobbying efforts. The next development was the Business Roundtable's revised definition of the purpose of a company. Your slide seems to be a little bit different than mine. The Business Roundtable, as some of you will know, is one of the most significant civil society organizations in the world, at least in the abstract. The organization comprises nearly 200, essentially US multinationals, employing 15 million workers with an annual revenue of $7 trillion. The organization has among its members some of the most famous and most powerful companies in the world, like Amazon, Apple, Coca-Cola, ExxonMobil, Ford, and IBM, and 3 of its bank members, BNY Mellon, Goldman Sachs, and JP Morgan Chase, have 7.2 trillion in assets under management. In August of, I forget if I mean 2019 or 2020, I think I mean 2019, the Business Roundtable announced it was replacing its long-held view that maximizing shareholder value is the defining corporate goal with a new statement of purpose. The statement reads in part, we share a fundamental commitment to all of our stakeholders. We commit to delivering value to our customers, investing in our employees, dealing fairly and ethically with our suppliers, supporting the communities in which we work, generating long-term value for shareholders. Reporting on the new statement, the Financial Times, which I've often called to my students the house organ of the free market system, the Financial Times said, an important shift may be underway. The update of corporate purpose from the Business Roundtable encapsulates a major change in thinking. And then a comment, an op-ed piece that came with it said, one of the US's biggest business groups has dropped the shareholder primacy that has driven capitalism for half a century. It's a significant departure. The change amounts to a call to reform capitalism, as populism and climate change concerns have led politicians and activists to demand that companies consider the impact on the world beyond their balance sheets. The next slide, please. The next, I want to just make a comment about the financial crisis, which you're all familiar with. The 2007-2008 financial crisis resulted in the most severe recession since the Great Depression. Household wealth in the States alone fell by $14 trillion. Unemployment soared by many millions across many countries. In the United States alone, more than 4 million jobs were lost in the first 6 months after October 2008. Unemployment in the OECD countries rose by a further 8 million. The British Medical Journal cited an increase in suicide rate across 54 countries, especially on the part of working age men. Further, the OECD noted an additional 260,000 cancer-related deaths due to stress in the OECD countries. In its 2011 report, the Financial Crisis Inquiry Commission attributed a substantial measure of blame to banking behavior, including on the part of some of the largest and most prestigious banks, citing, for instance, dramatic failures of corporate governance and risk management, a combination of excessive borrowing, risky investments, and lack of transparency. And thirdly, a systematic breakdown of accountability and ethics. One further immediate result of the financial crisis was, as I dare say all of you know, that the reputation of banks dramatically plummeted. In polls conducted by the Edelman Trust Barometer, financial institutions had placed toward the very top of the polls in 2006 and 2007 and 8. In the very next poll, released in January 2009, taken in the previous autumn, the reputation of banks sunk to almost the very bottom, ranking 11th out of 13 industry sectors. For the next decade, banks scored toward the very bottom of any of the 12 to 13 industry sectors. Banks, it's fair to say, were in bad odor. In the 2020 Trust Barometer, the poll for which was taken the previous autumn, financial institutions placed at the very, very bottom, ranking 15th out of 15 industry sectors. It's one of the best worldwide surveys, as you probably know, of popular opinion. Edelman had surveyed 34,000 plus people across 28 markets. The financial crisis and the resultant dramatic decline in corporate reputation led to soul searching on the part of many banks. Perhaps the most significant consequence after years of discussion has been the production of, in effect, guidelines and pledges regarding more responsible banking behavior, called the Principles for Responsible Banking, launched at the UN last autumn. I now want to make a few comments about the principles for responsible banking. I'll try to confine myself to maybe 3 or 4 minutes. The principles were launched in September of last year. Remarkably, on the very day of the launch, 132 banks holding some $47 trillion in assets solemnly promised to uphold the principles regarding all their banking activities. The 132 banks that signed on that very first day represented 1/3 of the global banking industry from nearly 50 countries. The next slide, please. Since the principles were launched only a little more than a year ago, more than 60 other banks have also solemnly pledged to honor the principles. As of yesterday, there are now 199 bank signatories, representing approximately 40% of global banking assets. The banks collectively have approximately $60,000 billion, that is to say $60 trillion in global banking assets. The next slide, please. So what have the banks promised? Each bank has solemnly promised to honor the following 6 principles. Alignment. Excuse me. The bank promises to align its business strategy to be consistent with and contribute to the need of individuals and of society's goals, as expressed in the Sustainable Development Goals, the Paris Agreement on Climate Change, and other relevant frameworks. Principle 2, the bank solemnly promises to increase its positive impacts while reducing its negative impacts on people and the environment resulting from banking activities. Principle 3, clients and customers. The bank promises to work responsibly with clients and customers to encourage sustainable practices. Principle 4, stakeholders. The bank promises to proactively and responsibly consult, engage with, and partner with relevant stakeholders to achieve society's goals. Governance and culture. The bank promises to implement its commitment on the principles through effective corporate governance and through a culture of responsible banking. And then finally, principle 6, transparency and accountability. The bank promises to periodically review its implementation of the promises and to be transparent about and accountable for the bank's impacts and its contribution to society's goals. Well, these are really, in all fairness, quite a set of promises. In an effort to ensure that the promises will be kept, the bank signatories have established a number of bodies to facilitate implementation: a banking board to monitor the keeping of the promises, 11 working groups to develop knowledge about what to do, because as the report said, the banks require guidance. These are some novel activities for many banks. A civil society body to advise the working groups on appropriate implementation. The banks, in all fairness, have to be given credit for making these solemn promises in good faith. Summing up the first year, the Secretariat commented, "There's much to celebrate. But there are serious problems." Let me just mention 2 of them. The NGO Bank Track, published a couple of months ago now, its 2020 report on fossil fuel financing, which indicated that a number of the signatory banks were continuing to support the fossil fuel industry. 35 global banks had financed the industry to the tune of $2.7 trillion in the 4 years since the Paris Climate Change Agreement. Stakeholder interest in responsible business behavior is not going to go away. There will be greater interest in fairness. There will be greater interest in equality. There will be greater interest in ethical behavior. There are a number of pieces of evidence about this. Let me, I guess, given the time, give you only one. Because banks have been cooperating with government and the general public in many countries, they have in recent weeks received credit for what they've done. And in a spring publication by the Edelman Trust Barometer, the banking sector rose from the very bottom of the 15 industries, where it had been for almost a decade, to the middle of the industries. Taken all in all, it was in reality a substantial improvement. People are recognizing the banks are trying. But the behavior of capitalist enterprises is fundamentally being called into question. It's hard to emphasize, or rather overemphasize this. In a remarkable development in the 220 Edelman Trust Barometer, the majority of people in 22 countries out of the 28 countries surveyed agreed with the proposition: capitalism, as it exists today, does more harm than good in the world. Well, when I first read that, I must say I was surprised and greatly shocked. The next slide. In the next slide, just for your interest, you can look at it later. I give you the list of countries who agreed capitalism was doing more harm than good, and the few countries that said, no, capitalism is still okay. The next slide, please. There is a growing public demand for responsible business behavior. In the 2020 Edelman Trust Barometer, strikingly, 76% of respondents from 28 countries declared that a company's ethics, that is to say its responsible behavior, was more important to trust in a company than the competence of its leaders. Further, 87% declared that a company should serve all of its stakeholders, including therefore employees, customers, communities, and society at large, and not simply its shareholders. Let me conclude by saying that these are, I think, really tremendous, dramatic developments, and they're not going to go away. There's going to be further pressure on banks to behave responsibly. There is no doubt about it at all. I have a few more slides which I'll ignore that you may wish to look at yourself about the attitude of the World Economic Forum. And let me simply say, I get to the very last slide, if you go past one or two. Let me simply say thank you for your attention. I've put my email address on the very last slide in case any of you might wish to communicate with me about the broad issue of responsible banking, or for that matter, about the broad issue of responsible business behavior. Now, it's been a pleasure to be with you, and thank you for your attention.
Thank you so much, Professor Driscoll. A lot to ruminate on, a lot to think about, especially since here in Jamaica, we are also having challenges with the quote unquote responsible behavior of banks in this pandemic world. I would just like to see if we can take a few questions. I know a few questions were already answered online, but there are a couple that have not been answered, and I am now going to throw the first one out to perhaps, I don't know if Professor McDonald, Dr. McDonald or Professor Driscoll, you'd also want to answer this. What do you think is the greatest threat to effective regulation of a financial services industry?
I think that the threats really remain the same. You have to watch for the behavior of banks, the riskiness of behavior. And I'd like actually just to go back to the financial crisis on which I have written about in Fannie Mae and Freddie Mac, turning the American dream into a nightmare. Because my point there, banks also need to be very careful on how they respond to political pressure. In the run-up to the financial crisis, the political pressure on banks was enormous, in that they should lend mortgages, provide mortgages for people who could not possibly pay it back. And that was where the political pressure came from, and the government quasi-governmental agencies, the government-sponsored enterprise of Fannie Mae and Freddie Mac to push that agenda. Now, if banks allow themselves to be pushed into lending money people who cannot pay it back, sooner or later the crunch comes. And sooner or later the crunch came. And in the end, actually, many people who had, using those procedures, bought their own homes, lost, communities were damaged, of course, unemployment and so forth. And that was the ultimate cause to me of spreading the financial crisis throughout the whole world. That's complicated, complicated processes by which that happened. But so I think banks have to judge very carefully how they are going to respond. And I think that their prime purpose is treating those properly, bearing in mind that the shareholders are major investors, i.e., it's not a few rich people, it is many ordinary people saving for their pensions and their investments through mutual funds and through pensions. Those are the major shareholders of banks, and it is very important that banks take those into account. Community, widening the concept of shareholders, I think, is extremely difficult. If you do that, I like to use a simple illustration here. We have a bank with branches in a particular city. Then there is a proposal to build a factory. The factory will actually employ a lot of people in the town. But there are many people who don't want the factory built near them. That's the sort of thing that happens. It is not the bank's responsibility to make that judgment. That is up to the local authority, who has to take into account the interests and try and balance the interests of one to another. I think there are great dangers here in widening the stakeholders as much as has been done, and it may actually be impossible for the bank to make that particular decision, because it's not actually in their gift to make that decision. So the risks are always the same. Risks of overlending, taking too great a risk in the kind of lending that you do, taking too great a risk in the kind of investments that you, ignoring quick ways of making money by your employment. About earlier. And keeping to the principles governing a bank's behavior, that's tough enough to do. And I think that that is the function of a bank. And of course, it is also a conduit and a contributor to the economy. And that is very important as well.
Thank you. Very comprehensive answer, I think. There was a question that was answered already by Mark from the FSC about the legal framework. What would be the legal framework to regulate a decentralized pseudonymous currency, in other words, cryptocurrency?
And I would say, first we need to look at the international regulatory authorities, standard setters, excuse me, like the Financial Stability Board, like FATF, IOSCA, and so on, have already begun to consider this. And let me give you one example. There was a period of, I called it the Wild West period in 2017, when those who were promoting particular cryptocurrencies or crypto assets, coins as they might well have been called, were called, initial coin offerings. It sounds very much like an IPO, but it was minus all the regulatory surround of an IPO, to the extent that many ICOs did not even have the name, address, contact details of the company that was launching its particular ICO. The so-called white paper consisted of what kind of product we're going to approach, how we are going to develop our version of a blockchain or whatever. That was entirely technical. Most people wouldn't understand it, even if they located it. And yet people were encouraged to invest, and then gradually various regulatory authorities began to regard an ICO as an IPO and subject to the same requirements to protect consumers, to explain what exactly it was they were promoting, what profits they expected to make and so forth. So slowly that is moving on. Interestingly enough, just one more point here. Cointelegraph, which is one of the main magazines in this field, looking at the ICO Wild West period, okay, here are the guidelines that ICOs to follow. And the guidelines that were being recommended by the industry to impose on newcomers, recommended, they couldn't actually impose them, of course, were really very similar to the kind of regulations you expect to find in place for an IPO in regulatory authorities throughout the world. So it's a move forward. Slowly these are being regulated. The standard setters, the international standard setters have all produced their proposals up to stable coins and global stable coins. And if you want to know how that whole area should be regulated, then you can see the general standards that are laid down, which should be then applied in each country's regulations.
Okay, thank you. Just a follow up though, Dr. MacDonald, whether you consider it would be better to have a rules-based or a principles-based framework.
As I was trying to say, I don't really recommend both, because the principles as I've read them to you and the kind of principles that other standard setting bodies lay out are very general.
Okay, okay. Okay. I have a question that I will ask either Ingrid or Mark to respond to. Has the FSC provided guidance on tokens that will not be considered securities? For instance, utility tokens.
Okay, if the tokens would not be considered securities, then I really don't think that the FSC would provide guidance on those. The BOJ, as Mark indicated, has taken the lead basically in dealing with currencies and cryptocurrencies. So where current tokens would fall within that remit, that area. I highlighted that the Bank of Jamaica Act has controls regarding offering of currency and the use of currency in Jamaica and what qualifies as such. And so I would think that my colleagues on the Bank of Jamaica would be better able to answer that question. But as far as the areas that fall outside of the remit of the FSC are concerned, we would not issue guidance on those matters.
And just one final question. Does the FSC have plans to utilize the sandbox in securities regulations?
So the sandbox approach is something that we are looking at. We would have absolutely no difficulty utilizing, and that would occur on a case-by-case basis because based on the nature of the product, we'd have to examine each one individually. Generally, what we have been doing at this time, we have been engaged in a lot of research, training, innovation, cooperation, and dialogue with the industries to understand what it is that persons are interested in offering, how we can structure regulation. We have actually had dialogue with other regulators on the subject, and so I think this is where we are.
Okay, thank you. So thank you very much for all the interest. I saw the questions started to come in a little later in the presentations. Mark, I will ask you to just look at the Q&A, and there is one other question that you could perhaps respond to. So again, thanks to all our presenters, really well done. A riveting first session. I'm happy to have chaired this session. One big takeaway from me, Dr. McDonald, is some of those scammers were clearly not spelling bee champs with all their grammatical and spelling errors, which I have also noticed. So that's a big takeaway from me. But thanks again, everyone. We're going to be taking a break, and we resume at 12 promptly, not Jamaica time, promptly. And we will go into our next session, which will be hosted by Dr. Blake. And then thereafter, we will go into the book launch. So take a break and come back at 12 o'clock. And remember to check in with when the prompt comes up for the electronic check-in, that you check in. So this will ensure that you can get your CLPD points. Dr. Ali, is there anything else I did not cover?
No, thank you very much, Mrs. Aldred. Excellent session. Thank you to all our presenters. Really insightful and informative. Unfortunately, we don't have more time because I know this is just the beginning of the conversation. So I once again thank you, and thank you too, Mrs. Aldred. And now we go to the break and see you all back in what, 22 minutes to be precise. See you soon. Thank
Okay,
you.
bye-bye, everybody.
Bye.
Thank you. Thank you.